also covered by the Honorable Court in a famous case, in a recent famous case, Vishakha versus State of Rajasthan, reported at 1997 Supreme Court 3011, by laying down the guidelines regarding the protection of the women at the workplace. In other words, while laying down such guidelines, enacting law, it does not mean that the judiciary overreaching or usurping the functions exercisable by other organs of the state. Rather, it is merely filling in the gaps and not preventing the legislature to enact law to meet such situations. In fact, the Protection of Women Against Sexual Harassment and Workplace Bill 2010 was introduced in the Lok Sabha about 3 days back, thereby further showing that the guidelines laid down in the aforesaid judgment of Vishakha versus State of Vigyan did not preclude the legislators from enacting the statute in any manner. The view of the school of thought characterizing the approach of the judiciary as being overreach appears to be based on the fact that the judiciary cannot exercise such law-making functions because it is a political organ, and the Constitution states that all law-making to be a result of political debate and of dialogue. This view, however, can be addressed by stating that the tremendous public confidence reposed in the judiciary today itself is due to the fact that it is apolitical. The success of the judiciary in India is a result of this public trust and the confidence reposed in a political process of often highlight differences with those differences in ethnicity, caste, religion, culture, or linguistics. The judiciary process seeks to bring all these and places the meaning of indigenous on the top. The judiciary helps the nation move forward. It does not overreach, but merely proceed. Thank you very much.
Thank you, Mr. Rota. Well, now I call upon Justice Rizni R. Mizamanda, High Court of Malawi.
Greetings, Mr. Kamanda. I'm a judge at the High Court from the Republic of Malawi. Malawi is a small country in the southern part of Africa, close to Mozambique, Tanzania, and Zambia. You can also think about South Africa. That's where I come from. And Malawi's legal system is pretty much like the Indian legal system. But I must say that India is renowned for being the largest democracy in the world. First of all, let me thank the organizers for giving me this opportunity to come here and share some few thoughts with colleagues and perhaps learn a few things as well. Like I said, Malawi is a democracy. It's a new democracy, as it were. It only became a democratic state in 1994. Before that, it was a dictatorship. Now, when we talk about the relationship among the judiciary, legislature, and the executive, we are really talking about, well, it only becomes relevant when we are not in a dictatorship. The talk about the relationship only becomes relevant when we are not in an authoritarian regime or an autocracy, or indeed where no tyranny reigns in the running of the affairs of the state. We talk about constitutional democracy with three separate arms of government, being the judiciary, the executive, and the legislature. When we talk about democracy, we talk about democracy not as an idealistic or abstract concept, but we are talking about the real driving force towards progressive well-being of individuals and societies. So when we think about democracy, we should not think about it as an abstract concept, but something that is going to make our society better. And democracy is not as a tyranny of the majority, because the majority can also be tyrannical. The rule of the majority can be taken too far, such that you trample over the rights of the minority. So democracy must not be thought of in terms of the majority, the tyranny of the majority. This is a democracy where both the rights of the majority and the minority are respected. And that's where you're talking about the relationship amongst these three arms of government or state. Constitutional democracy as a foundation of good relationship among the judiciary, legislature, and executive means that the Constitution properly provides for the separate status, function, and responsibilities of the three arms of government, or three arms of state. Of course, we know of different types of democracies, majoritarian democracy, pluralistic democracy, elitist democracy, constitutional democracy. I don't need to define all those. I think that the people here are well familiar with all these. But the idea of separation of powers began many years ago. It began with John Harris, if you remember, 1656. And then, of course, in 1690, John Locke, the English legal philosopher who idealized the idea of separation of powers. And then came to, in 1748, Montesquieu, who kind of refined that idea of separation of powers. The idea was that power should not be concentrated in one person or one individual or one body, but rather it should be spread out if it's going to work for the better of all the people. But why should we talk about the relationship among these three arms of government when we know that the Constitution clearly separates their powers? Why should we talk about the relationship? Why is it necessary to talk about the relationship? It is important to realize that constitutions do not spell out in detail how these three arms of state will exercise their powers. And so there is room for informal rules being applied in order to ensure that the machinery of government works. And it is where these informal rules come in that we begin to see problems of the relationship amongst these three arms of government. Why? First of all, because there's mutual suspicion of intentions and operations of the other branches of government. The judiciary will suspect that the executive will do something else, and the judiciary will suspect that the legislature is going to do something else. Similarly, the executive will do the same thing. The executive will also do the same thing. The second reason is failure to distinguish between what amounts to checks and balances under the Constitution as properly provided and what is unwarranted interference with institutional performance of each one of these arms of government. The third reason is competition of supremacy for each branch. Each branch would like to be supreme over the other, would like to show the muscle. And because of that competition, you have problems of relationship amongst these arms of government. The fourth reason is lack of appreciation of the constitutional, of what constitutional democracy means. That in constitutional democracy, it is the constitution that reigns supreme. You get rid of parliamentary supremacy, you also get rid of executive supremacy, you get rid of judicial supremacy. The fifth reason is obsession with power and a misapprehension of what once one is elected into power, then one has got all the solutions social problems. Once you have that misapprehension, that you know it all, then you're bound to initiate conflicts amongst the different arms of government. But is it possible to have a good relationship? Yes, it is. It is possible to have a good relationship amongst these three arms of government, despite the many difficulties that we tend to face. That is what modern constitutionalism is all about. It envisages a good working relationship amongst the three arms of government to ensure that they promote the personal or individual well-being or societal well-being progressively. And the rule of law also envisages that there should be respect for the rule of law, that everybody is subject to the rule of law, whether you are in the executive, in the judiciary, or in the legislature. You are all subject to the rule of law. And if we respect that, it is possible to have a good working relationship among the three arms of government. I'm told that I'm running out of time. Any desire for competition amongst the three arms of government should be gotten rid of. If you get rid of that, then you are going to ensure that you develop a good working relationship. Again, for purposes of progressive well-being of society. The three arms of government represent division of labor. They form specialized institutions which all contribute towards progressive well-being of society. How to achieve it also, you might wish to have heads of the executive, the legislature, and judiciary meet from time to time in order to them appreciate their different roles, and therefore what they understand about their roles will cascade down to the various people. The judiciary upholds the good relationship by using the power of judicial review. As was said earlier, the judiciary is given the power to interpret the laws, and it is only the judiciary that is given that authority to interpret the laws. By doing judicial review, it ensures that there is good working relationship. Again, the legislature should exercise its supervisory roles as is provided for under the Constitution. Apart from making laws, the legislature also supervises the workings of government. The different committees of the legislature help in supervising the workings of the executive. Again, the executive must know that the resources, as approved by Parliament, must be used for the purposes that are intended, and that must not overreach, must not deny the other arms of government the resources. Outside these three arms of government, you strengthen intra-party democracy. That is outside the three arms. Also, you strengthen civil society or non-state actors to ensure that the working relationship is good. You also improve literacy levels in the country so that people are not, the illiteracy of people is not abused to the advantage of some strong and powerful people. And also, of course, reduce poverty, and that's something that we've been talking about. Well, my time is up. I think I've got to stop here, but I think this conference can also suggest how we can better improve the relationship that is always acrimonious amongst these three arms of government. Thank you very much.
I call upon Dr. P. Ratnaswamy, Senior Advocate, Supreme Court of India.
And practicing lawyers, ladies and gentlemen, I do not like to ponder over the technicalities of separation of power. Rather, I would like to place before you what could be the modus operandi, what could be the suggestive measures, so that we can strengthen separation of powers rather than making critical assessments and statements vociferously. We believe in democracy. Rather, I adhere to judicial democracy, not being simply belonging to that fraternity, but it has proved success in the glorious history of democratic world. The judiciary is not committed to individual serfdom. It doesn't belong to one man or a group of unorganized or unaware of consequences of their pronouncements. They belong to a sector. They know their responsibilities. They are aware of their judgments, pronouncements, what they are doing and for whom they are delivering the judgments, and they are to whom working for. But it's more important, there is a lacking of judicial accountability. Globally, all democratic countries, even dictatorship, they struggle hard to find solutions to judicial accountability. Yet somewhere it is creating a nervous in the minds of fraternity of judiciary. The politicians, they like to have upper hand, criticizing